Imagine handing over your financial life to someone, trusting them completely with your taxes. You're relying on their expertise, right? To navigate all that complexity in tax law. Maybe even find some smart, legitimate ways to lower your tax bill. Real ethical tax saving strategies. But what if you find out they've been playing well, fast and loose with the rules, potentially putting your whole financial future on the line? What happens then? I mean, who holds these professionals accountable? And what are the actual boundaries, the lines they absolutely cannot cross? The ones that protect both you and, the system itself. Today, we're doing a deep dive into this surprisingly robust rulebook. It governs pretty much everyone, from your local tax preparer right up to those high-powered tax attorneys and CPAs. We're going to unpack the really strict standards they're held to and the serious consequences if they step out of line. Understanding this helps you know how you're protected and how to make sure any tax-saving advice you get is actually sound.
That's exactly right. That's our mission today. We're diving into these federal regulations. Lots of people just call them Circular 230 informally. These rules, they lay it all out pretty clearly. Who's actually allowed to represent you in front of the IRS, what their fundamental duties are, what they can't do, and, crucially, what happens if they mess up. And this isn't just, dry legal stuff or administrative jargon. It's really about understanding the safeguards, the ones that are there to protect you, the taxpayer, to make sure the advice you're getting is legit, and honestly, to keep the whole tax system credible. Because let's face it, the best tax-saving method is always going to be one that's compliant, delivered by someone ethical and competent.
That makes perfect sense. Okay, so let's kick things off. Who are these authorized players? The gatekeepers of your tax world, so to speak. What does practice before the IRS really, truly mean? Because it sounds like it covers a lot more ground than just, filing your 1040 once a year.
Oh, it's way, way broader than most people think. The official definition of practice before the Internal Revenue Service is incredibly expansive. Basically, it covers almost anything you do or say when you're representing a taxpayer to the IRS or any of its folks. Anything related to that taxpayer's rights, their privileges, their liabilities under tax law. Think of it as pretty much any interaction where you're standing in for someone else on a tax issue.
Anything you do or say. That sounds like a really wide net. Can you give us some specific examples, like what kinds of actions fall under this?
Sure. So it's not just the act of filing the return itself. It includes preparing the documents that go to the IRS, actually filing them, corresponding with the IRS, writing emails, letters, and definitely rendering written tax advice. And this advice part is broad, too. It specifically mentions advice on, quote, any entity, transaction, plan, or arrangement having a potential for tax avoidance or evasion. So if your advisor is giving you strategic advice, maybe about setting up a business structure or some sophisticated tax planning idea to, minimize your taxes legally, that all counts as practice. Oh, and representing clients at conferences, during audits, at hearings, meetings with IRS staff, all of that too.
Wow. So yeah, definitely not just crunching numbers. It's strategic advice, communication, even defending positions. That scope really highlights how important it is to know who's actually allowed to do this stuff. So who are they? Who are the authorized players?
Okay, so there are several main categories. First up, you've got attorneys. These are individuals licensed by a state bar, right? And crucially, they can't be currently suspended or disbarred from practicing before the IRS. Their state law license basically gives them the green light, assuming they're in good standing.
Right, makes sense. Lawyers deal with legal matters.
Exactly. Then, very similar, you have certified public accountants, CPAs. Again, licensed by a state, can't be suspended or disbarred by the IRS. Like attorneys, they don't need a special declaration just to give written tax advice, but that advice definitely falls under practice before the IRS.
Okay, attorneys, CPAs, those are familiar. But then you mentioned folks enrolled directly by the IRS, like enrolled agents. That sounds interesting, especially if you're looking for someone really focused on tax.
Yes, that's where you get the tax-specific designations. Enrolled agents, or EAs. These individuals are enrolled directly by the IRS. How do they get there? Well, usually one of two ways. Either they pass a pretty tough comprehensive exam showing, quote, special competence in tax matters, or they qualify based on specific past employment with the IRS.
So not just any IRS job, right?
Yeah,
It
yeah.
has to be specific experience.
That's right. For the former IRS employees, they need at least 5 years of continuous work where they were regularly applying and interpreting tax law, income tax, estate tax, employment tax, that sort of thing. Or, alternatively, it could be 10 or more years total, as long as 3 of those were recent, like within the last 5 years before applying. And an important point, EA enrollment is only for individuals, natural persons, not firms or companies. It shows the IRS takes this direct enrollment seriously. They want proven competence or deep experience.
It certainly sounds like it. What about those really specialized roles? I think you mentioned retirement plans.
We do. We have enrolled actuaries. Now, these are highly specialized. Their practice is strictly limited to certain parts of the tax code dealing with employee benefit plans. Think pensions, 401ks, all those complex funding and compliance rules. They handle the heavy math and legal side of those plans.
And I think there was another one related to retirement plans, even more specific.
Yes, enrolled retirement plan agents, or ERPAs, also enrolled by the IRS, but their scope is narrower still. They focus on specific programs, like helping plans get IRS approval letters, fixing compliance issues under certain programs, and dealing with specific forms, like the 5300 and 5500 series. But crucially, they can't handle the actuarial forms or duties. That's the key difference between them and enrolled actuaries.
Okay, that's a vital distinction if you're dealing with retirement plans. Now, what about the preparers many of us use for, say, our individual returns, the more common tax preparers? What's their scope?
Right, those would generally be registered tax return preparers. These folks are designated by the IRS primarily for, well, preparing and signing tax returns and refund claims and related documents, but their authority to actually represent you is quite limited compared to the others. They can represent you before revenue agents or customer service reps during an examination, but only if they were the one who actually signed the return being examined.
So wait, does that mean they can't handle things if it goes higher up, like appeals or dealing with IRS lawyers?
Generally, no. Unless there's a specific rule allowing it, they usually can't represent taxpayers before appeals officers, revenue officers, or IRS counsel. And their ability to give tax advice is also restricted. It's limited to the advice necessary to prepare a tax return, claim for a refund, or other document meant for the IRS. So it highlights a pretty big difference in scope compared to attorneys, CPAs, or EAs. It's really important for taxpayers to get that distinction when they need more comprehensive advice beyond just filling out the forms.
That is incredibly important to understand when choosing who to work with. Are there any other, maybe less common situations where someone might represent a taxpayer without being a designated practitioner?
Yeah, the rules allow for a few limited exceptions. Like you can represent yourself, obviously, or a member of your immediate family. A full-time employee can represent their company, a general partner can represent their partnership, an officer their corporation, and so on. Fiduciaries, too, like trustees or executors, they're basically treated as the taxpayer themselves for these rules. Oh, and one key restriction. Government employees, like state tax officials, are generally barred from practicing if it violates federal law or involves spilling confidential info they got from their job. Keeps things separate.
Okay, so clear gates to get in. But once you're an authorized practitioner, how do you stay in? It can't just be a one-time thing, right? Is there ongoing stuff involved?
Definitely not one and done. Maintaining eligibility is a continuous, pretty rigorous process. And continuing education, or CE, is absolutely central, particularly for EAs, ERPAs, and registered tax return preparers.
What kind of CE are we talking about? Sounds like they have to keep learning to stay sharp.
They do. For enrolled agents and ERPAs, it's a significant amount. They need a minimum of 72 hours of CE credit every enrollment cycle. That's a 3-year period. And it's not just hitting the total at the end. Within each of those 3 years, they need at least 16 hours, and importantly, at least 2 of those hours must be on ethics or professional conduct. Over the whole 3-year cycle, that adds up to at least 6 hours, minimum, just on ethics. Ensures they're keeping up with tax law and professional standards.
So constant learning, plus a real focus on ethics, what else keeps them eligible?
Well, before they even get approved initially or when they renew, they go through a couple of checks. There's a federal tax compliance check. This basically asks, have they filed all their own tax returns? Has they paid their federal taxes or made arrangements to pay? And then there's a suitability check. Have they engaged in any, disreputable conduct that would justify kicking them out? It's a powerful check. Even if you pass the exams, if your own tax house isn't in order, you might not get approved. Really reinforces the integrity needed.
Absolutely. You wouldn't want advice from someone who can't handle their own taxes. So what if they don't meet these ongoing requirements, like they skip the CE or don't respond to IRS notices? Do they just lose their status?
If they fail to meet the CE or fee requirements or ignore IRS notices about it, they get put on an inactive status list. While they're inactive, they are completely barred from practicing before the IRS, period. They also can't use their titles like enrolled agent or ERPA or even imply they're eligible to practice. It's a clear, immediate consequence. It reinforces that this is an ongoing duty.
Right, no practice, no title sends a clear message. Can they get back to active status? Is there a way back?
Yes, there are ways back. Someone on inactive status can apply for reinstatement. They have to file the renewal application and show proof they've completed all the required CE for that cycle, plus pay any fees. There's also something called inactive retirement status for folks who aren't practicing anymore. They can keep their status without doing current CE, but if they ever want to come back to active practice, they'd have to catch up on requirements, including CE. This retired status isn't an option if they're currently under disciplinary review, though.
Okay, so clear gates in, ongoing hoops to stay in, all about competence and integrity. Which brings us to the next big piece, the advisor's playbook. Once they're authorized, what are the specific duties, the restrictions, the sort of best practices they need to follow? Let's start with their core ethical duties.
Okay, a really fundamental one is about information to be furnished. Basically, if a proper IRS officer asks for records or information related to a case, the practitioner must promptly hand it over. The only real out is if they genuinely believe, in good faith and reasonably, that the information is legally privileged, like, say, certain attorney-client communications.
What if they don't actually have the info? Maybe the client has it or someone else.
Good question. If the records aren't in their possession or their client's control, they have to tell the IRS officer promptly, and they need to provide any info they have about who might have it. They're expected to make a reasonable inquiry of their client to figure that out. And critically, they cannot interfere or even try to interfere with the IRS lawfully trying to get information unless, again, that narrow privilege exception applies. So cooperation is key, but they also protect legitimate client confidentiality.
That's quite the balancing act. Now, what about something really common, finding out a client made a mistake on a past return? Or maybe left something out?
Ah, yes, this is a critical duty, knowledge of client's omission. If a practitioner finds out their client hasn't complied with tax laws, or made an error or left something off a return or a document already sent to the IRS, they have a duty to promptly advise the client about it. And not just tell them about the error, but also advise them of the consequences under the tax code and regulations. Now, this isn't about the practitioner ratting the client out to the IRS. It's purely about making sure the client knows the situation, the potential risks, and can make an informed choice about how to fix it.
That feels really important for the client, knowing their advisor has to be straight with them. What about just general professional conduct, like being timely or avoiding questionable associations?
Definitely. They have to exercise due diligence. That means they can't unreasonably delay things. They need to handle matters before the IRS promptly. And yes, there are rules against, let's call them shady associations. Basically, they can't knowingly get help from or give help to anyone who's already been suspended or disbarred from IRS practice if it relates to tax matters. Keeps the process clean.
And what about former government folks? Can someone leave the IRS and immediately start advising on cases they worked on? Seems like a conflict waiting to happen.
You're right, that's addressed too. Practitioners can't accept help from former government employees if it would violate federal conflict of interest laws. This prevents, for example, a former IRS employee from representing someone on a specific matter they were personally involved in while at the IRS, or trying to influence rules they helped create for certain periods after leaving. Maintains integrity and separation.
Okay, all about trust and avoiding impropriety. Let's switch gears slightly to something everyone cares about. Fees. How are tax pros supposed to charge? Are there limits?
Yes, this is a big one, and the rules are pretty specific. First off, a general standard. Practitioners may not charge an unconscionable fee. That basically means a fee that's grossly excessive, way out of line with the value of the service, protects clients from being ripped off.
Unconscionable is strong. But what about contingent fees? This gets really interesting, right? Because it affects how you might pay, maybe even thinking it's tied to tax savings. Can they charge based on the result, like a cut of the refund?
Generally, no. A practitioner may not charge a contingent fee for services rendered in connection with any matter before the Internal Revenue Service. That's the basic rule. And contingent fee is defined really clearly. It's any fee based, even partly, on whether a position taken on a return avoids an IRS challenge or is upheld by the IRS or in court. This includes fees based on a percentage of the refund, a percentage of taxes saved, or any deal where the fee depends on the outcome. It even covers things like guarantees, where the practitioner might refund their fee if a position gets overturned.
Wow, that's a major restriction. So if I hire someone to do my regular annual tax return, they can't charge me, say, 10% of whatever refund I get, or based on how much tax they save me compared to last year.
Correct. That general prohibition is there, mainly to prevent practitioners from having a direct financial stake in taking overly aggressive or iffy positions on original returns. The idea is to keep their advice objective and focused on compliance from the start, not driven by chasing a bigger fee that might put you at risk.
Okay, that makes sense for ethics. But you mentioned exceptions. This is key for listeners. When are contingent fees allowed? When might you see this kind of fee structure legitimately?
Right, there are four very specific, important exceptions. First, contingent fees are allowed for services related to the IRS examining or challenging an original tax return. So if you're already under audit or the IRS is formally questioning your return, your representative can charge a fee based on the outcome of defending that return. The issue is already on the table, so to speak.
Okay, so if the IRS initiates something, the game changes. What's exception number two?
Second, they're allowed for services related to an amended return or a claim for refund, but only if that amended return or claim is filed within 120 days after the taxpayer gets a written notice of examination or a written challenge to the original return. It's a specific time frame linked to an IRS action.
Got it. Third.
Third, it's allowed for claims for credit or refund that are filed only to determine statutory interest or penalties assessed by the IRS. Very narrow, just about figuring out interest or penalties already on the books.
And the last one, what if it goes beyond the IRS, like to court?
That's the fourth exception. Services connected with any judicial proceeding under the Internal Revenue Code. So if your tax dispute ends up in tax court, district court, or another court, contingent fees are generally permissible. Litigation often involves different risk calculations where these fees make more sense.
That's a big difference. It seems like the exceptions kick in mostly when the IRS is already involved or it's gone to court. Changes the dynamic. This also connects to another vital client issue, getting your records back. What if you have a dispute with your tax pro? Can they hold your documents hostage?
No, they absolutely cannot, and this is a powerful protection for you. Practitioners must promptly return any and all client records needed for the client to meet their federal tax obligations whenever the client asks for them. They can keep copies, sure, but they have to give back the originals or whatever the client needs. And crucially, a fee dispute generally does not excuse them from this duty. They can't hold your tax compliance hostage over a bill. Even if state law might let them keep records in a fee dispute, they still have to give the client reasonable access to review and copy those records if they're needed for federal tax obligations. You're never supposed to be stuck.
That is a huge relief for clients. What about conflicts of interest? Always a big deal in professional relationships, especially with sensitive tax info.
Absolutely fundamental. The general rule is a practitioner cannot represent a client if it involves a conflict of interest. This usually happens in two main ways. Either representing one client is directly adverse to another client, like arguing opposite sides of the same transaction, or there's a significant risk that representing one client will be materially limited by the practitioner's duties to another client, a former client, a third party, or even their own personal interests.
That sounds pretty broad. Can these conflicts ever be waived? Or is it just a flat no?
It's not always a flat no. There's an exception, but it has strict conditions. A practitioner can proceed despite a conflict if they reasonably believe they can still provide competent and diligent representation to everyone affected, and the representation isn't illegal, and critically, each affected client waives the conflict and gives informed consent, confirmed in writing. They need to get this written consent pretty quickly, usually when they spot the conflict, or within 30 days. And they have to keep these written consents for at least 36 months and show them to the IRS if asked. It's a high bar, ensuring everyone knows what's going on.
Full transparency makes sense. Okay, what about marketing? How can these folks advertise? And are there general best practices beyond just avoiding conflicts? What should a taxpayer watch out for in ads?
Right, marketing is regulated too. Practitioners can't use any public communication or solicitation that's false, fraudulent, coercive, misleading, or deceptive. Pretty standard ethical stuff. But specifically for EAs, ERPAs, or registered tax return preparers, they cannot use the word certified. That's reserved for CPAs. They also can't imply they work for the IRS. There are specific acceptable phrases like enrolled to practice before the Internal Revenue Service for EAs. So if an ad sounds too good to be true or uses fuzzy titles, that's a potential red flag for you.
Good tip. And these best practices sounds like going above just not breaking rules into what makes for really good ethical tax advice.
Exactly. These are aspirational standards for tax advisors generally. 4 key things. First, clear communication. Understanding the terms of the engagement, what the client actually needs the advice for, the scope of work. Second, solid fact-finding and analysis. Establishing the facts, figuring out what's relevant, checking if assumptions are reasonable, applying the law correctly to the facts, and reaching conclusions that actually hold water based on law and fact. Really doing the homework.
Thoroughness and diligence. What's third?
Third, advising on penalties. This is huge for you, the taxpayer. The advisor must tell the client about any penalties that seem reasonably likely to apply because of positions taken on a return. And they also have to explain any ways to potentially avoid those penalties through disclosure, if that's an option, and what's required for that disclosure. This applies even if the practitioner themselves isn't the one facing the penalty. It's about making sure you understand the risks and your options.
That's putting the client's interests first. And the fourth best practice.
Fourth is a general principle, acting fairly and with integrity in all their dealings with the IRS. And importantly, this isn't just on the individual. Firms that supervise tax advice or preparation must take reasonable steps to ensure their own procedures line up with these best practices. So, the firm has a responsibility too, promoting an ethical culture.
That spreads the accountability. Now, accuracy and diligence, especially with written advice, how much can an advisor just rely on what their client tells them? Do they need to be a detective?
It's a nuanced point. Generally, a practitioner can rely in good faith, without verifying everything, on information the client gives them. They don't have to audit every single number. However, and this is the big however, they cannot just ignore the implications of information they receive or already know. They must make reasonable inquiries if the information seems incorrect, inconsistent, incomplete, or just, fishy. It's about trust, but verify if red flags pop up. They can't turn a blind eye.
That's a crucial balance. What about the standards for actually signing a return or other documents going to the IRS?
They can't willfully, recklessly, or through gross incompetence sign anything they know, or should know, contains a position lacking a reasonable basis, meaning it doesn't have enough legal or factual support. Or if it takes an unreasonable position, something clearly not defendable, they also can't advise taking a frivolous position, basically, a totally baseless argument, often just to delay things. And they can't submit documents just to delay or impede tax laws or intentionally disregard rules. This seems aimed right at stopping advisors from pushing boundaries or suggesting sketchy stuff as tax savings.
It really does. So let's focus on written advice, especially for those complex tax avoidance or tax saving strategies. This seems like where the rules get really tight to prevent abusive schemes, right?
Exactly. This part is critical. Any written advice, including emails about federal tax matters, has to be some tough standards. It must be based on reasonable, factual, and legal assumptions. They need to reasonably consider all relevant facts and circumstances they know or should know, and use reasonable efforts to identify and ascertain the facts. Nor just taking things at face value if it seems off.
And what can they not rely on? That seems key.
They cannot rely on representations, statements, or findings they know or should know are unreasonable, incorrect, incomplete, or inconsistent. They have to relate applicable law and authorities to facts, link the rules to the situation. And here's the absolute kicker, the one that directly targets that audit lottery mentality. A practitioner must not, when evaluating a tax matter, take into account the possibility that a tax return will not be audited or that a matter will not be raised on audit.
Wow. That's huge, isn't it? It basically says you can't advise taking a risky position just because you think the IRS might miss it. It forces advice based on merit, not just audit odds. That significantly lowers your risk as a taxpayer, knowing your advisor isn't supposed to be gambling.
Precisely. It's a fundamental shift. The advice has to stand on its own legs, legally and factually, regardless of whether anyone might check it. The standard they're judged by is a reasonable practitioner standard, looking at all the facts, the scope of the advice, etc. And for opinions used to promote tax avoidance schemes, they look extra closely if the practitioner didn't know the specific taxpayer situation, because that generic advice is riskier. The onus is firmly on giving solid, defensible advice.
Okay, so we've covered getting in, staying in, the playbook. But what happens when things go wrong? When rules get broken? Let's talk sanctions and discipline. How do the rules define incompetence and disreputable conduct? What are the big red flags that lead to serious trouble?
Right, the regulations list a lot of things that count, though it's not exhaustive. Some really clear examples: getting convicted of any criminal offense under federal tax laws, or any crime involving dishonesty or breach of trust. Also, conviction of any felony under federal or state law if the conduct makes them unfit to practice before the IRS. So, serious criminal activity, especially financial, is a definite trigger.
What else falls under disreputable?
Things like willfully failing to file your own federal tax return, or actively evading or helping someone else evade federal taxes, trying to get clients using false or misleading advertising or hinting they have special pull with the IRS. That's a big no-no. Also, bribery, trying to improperly influence IRS actions with threats or gifts, false accusations, basically any attempt to corrupt the process.
That covers a lot of ground ethically, but there was one about the quality of advice itself, giving a false opinion. What does that entail?
Yeah, that's critical for advice integrity. It means giving a false opinion knowingly, recklessly, or through gross incompetence. And gross incompetence isn't just a simple mistake. It means things like gross indifference, really inadequate preparation, or a consistent pattern of failing the client. A false opinion could involve knowingly misstating facts or law, pushing a position known to be baseless, counseling illegal or fraudulent stuff, hiding required information, or consciously ignoring info that shows the facts are wrong. A pattern of bad opinions is a major factor here. It really emphasizes their responsibility for the advice they provide, especially on tax-saving ideas.
It really does sound serious. So when someone is found to have done these things, what are the actual punishments? What's the range of sanctions?
Well, after giving notice and a chance for a hearing, the Treasury Department can impose several sanctions. The mildest is censure. It's basically a public reprimand, a formal disapproval on their record. More serious is suspension. This bars them from practicing before the IRS for a specific time, could be months, could be years. And the most severe is disbarment. That's a permanent ban from IRS practice, unless they somehow get reinstated later, which is apparently quite rare and tough.
And can they get hit financially too? Fines on top of potentially losing their license to practice?
Yes, monetary penalties are also an option. These can be added to censure, suspension, or disbarment, or sometimes imposed instead of them. What's really interesting here is it's not just the individual practitioner who can be fined. If they were working for a firm or employer, that entity can also be penalized if the firm knew or reasonably should have known about the misconduct, holds the firm accountable for oversight.
That's a big incentive for firms to police themselves. How much can these penalties be? Is there a limit?
The penalty amount shall not exceed the gross income derived, or to be derived, from the conduct giving rise to the penalty. So the idea is to take away the financial gain from the bad behavior, make it unprofitable. Oh, and for appraisers who break the rules, there's a specific penalty, appraiser disqualification. Their appraisals can be basically thrown out as evidence in IRS matters, and they can be barred from testifying. A strong deterrent for bogus appraisals.
This sounds like a very formal, structured process. Can you walk us through how it usually unfolds, from complaint to decision?
Sure. It usually kicks off when an IRS officer or employee spots a potential violation. They make a written report detailing the facts. Generally, before things get formal, the practitioner gets notified in writing about the allegations. They get a chance to dispute the facts, add context, or explain mitigating circumstances, so they get heard early on.
Can they settle it at that stage, avoid a full hearing?
Yes, often they can. A practitioner can offer to consent to a specific sanction, like maybe a suspension, to resolve the matter without a full formal proceeding. The IRS can accept, reject, or suggest different terms. It's often a way to resolve things more efficiently if the facts aren't heavily disputed.
But if there's no agreement, it goes to a formal complaint and hearing.
That's right. If no deal is reached, the IRS files a formal complaint. It names the practitioner, now called the respondent, lays out the facts and law supporting the charges, and states the sanction they're seeking. The respondent gets time, usually at least 30 days, to file an answer. If they don't answer or don't deny something, it's usually treated as admitted. Then, the case goes before an administrative law judge, an ALJ. They preside over a formal hearing, which is typically recorded. Testimony is under oath, evidence is presented, witnesses can be cross-examined. It's like a mini-trial.
What's the burden of proof? Does the IRS have to prove its case beyond a reasonable doubt, like in criminal court? Or is it different?
It's different, and it depends on the sanction. This is interesting. For censure, or suspension of less than 6 months, the standard is preponderance of the evidence. Basically, is it more likely than not, like 51%, that the violation happened? It's a common civil standard. But for the heavier sanctions, monetary penalties, disbarment, or suspensions of 6 months or more, the standard is higher. Clear and convincing evidence. This means the evidence has to be strong, highly probable, leaving little doubt. It's not quite the criminal standard, but it's significantly tougher than preponderance. Same for appraiser disqualification. Higher stakes mean a higher burden of proof.
That makes sense. So after the hearing, the ALJ makes a decision. What happens then?
Yes. The ALJ issues a written decision with findings of fact, conclusions of law, the reasoning, and an order either imposing a sanction or dismissing the complaint. That decision becomes final after 30 days, unless one of the parties appeals it. Appeals go up to the Secretary of the Treasury or their delegate. On appeal, factual findings are reviewed for clear error, meaning they stand unless clearly wrong. But legal issues get a fresh look, reviewed de novo. It provides layers of review.
Seems thorough. But what about really bad cases? Can the IRS act faster? Is there like an expedited suspension for clear-cut, serious stuff?
Yes, there is an expedited suspension process for certain situations deemed particularly serious. It can be used if a practitioner within the last 5 years had their professional license, attorney, CPA, actuary, suspended or revoked for cause by their state board, not just for failing to pay dues, but for actual misconduct.
So, if their own licensing board already disciplined them seriously, the IRS can fast track. What else triggers it?
Also, if they've been convicted of a federal tax crime, Title 26, or a crime involving dishonesty or breach of trust, or any felony that just makes them unfit to practice, or if they violated conditions the IRS already put on them from a previous sanction, or if a court has sanctioned them for certain bad behavior in tax litigation, like delaying tactics, frivolous arguments, or not using available IRS procedures first, basically if they've already shown serious disregard for the rules or the law.
How does that expedited process work then? Is it immediate?
It's quick. The IRS issues a show cause order explaining why they propose suspension. The practitioner gets 30 days to respond and can ask for a conference. The suspension can then become effective pretty fast, either after the 30 days if there's no response, or right after the conference if the IRS decides they meet the criteria, or even if they just don't show up for the conference. It's meant for swift action in clear cases.
That is fast. But do they still get a chance for a full hearing eventually? Can they challenge it later?
Yes, absolutely. Even if they get hit with an expedited suspension, they still have the right to demand a full, regular disciplinary proceeding later on. They have to make that demand in writing within 2 years of the suspension starting. And if the IRS doesn't then issue a formal complaint within 60 days of that demand, the expedited suspension actually gets lifted automatically. Though the IRS could still pursue a regular case later, so there are still procedural safeguards.
It really sounds like a system with checks and balances aimed at protecting taxpayers. So finally, what's the public fallout from these sanctions? Is there a public record? How does this affect their ability to practice?
Yes, definitely. For public awareness and protection, the IRS maintains public rosters. These lists show individuals, and sometimes firms, that have been censured, suspended, or disbarred, or hit with monetary penalties. It also shows the status, active or inactive, of enrolled agents and registered tax return preparers, and lists disqualified appraisers. This allows you, the public, to check someone's standing before hiring them. It's crucial.
That's incredibly useful. And what's the practical effect? Obviously, suspension or disbarment means they can't practice, right?
Exactly. Disbarred or suspended folks are prohibited from practicing before the IRS for the duration. With a censure, they can still practice, but it might come with conditions attached. For example, if they were censured for a conflict of interest issue involving written consents, the IRS might require them to submit copies of all future client consents for a while, just to monitor them.
So even a censure can involve ongoing scrutiny. Can someone who's been disbarred or suspended ever get back in? Is reinstatement possible?
It is possible, but it's designed to be difficult. They can petition for reinstatement, but generally not until at least 5 years have passed since the disbarment or suspension started, or after the suspension ends, if shorter. And reinstatement isn't guaranteed. The IRS has to be convinced the person isn't likely to misbehave again, and that letting them back in is actually in the public interest. It's a very high hurdle meant to protect the system and the public.
Okay, so wrapping this up, what have we really uncovered in this deep dive? It seems the world of tax practice is anything but a free-for-all. It's a seriously regulated field with clear, demanding rules focused on competence, diligence, and just plain integrity. From the ongoing education, the specific ethical lines on fees and advice, right through to severe penalties for messing up these rules are all there for a vital reason: protecting you, the taxpayer, and keeping our tax system credible.
Absolutely. And understanding these rules, even just the basics, isn't only for the tax pros. It empowers you. It helps you ask better questions, spot the signs of a truly reliable, ethical advisor. In a world where tax law feels overwhelming, maybe the single best tax-saving method is just choosing someone who genuinely follows the ethical compass and the tough standards we've talked about today. Because honestly, the cost of hiring an unethical advisor, whether through penalties, audits, stress, or just bad outcomes that cost, can end up being way, way higher than any tax bill. This knowledge helps you make safer choices.